I'm going to talk about some of the core legal hurdles to cloud adoption. And let's look at it like this. I'm talking about legal hurdles. They're not necessarily insurmountable. So there's usually a solution out there. You've just got to work out what it is. And I think the big problem, the irony of this technology, which simplifies technology adoption for some and makes business, gives business a solution to pop out into the cloud, it becomes more simple. But it also then complicates the legal analysis because there are more and more questions. So in assessing any risk or any compliance, there's more than a contractual analysis required, and we've got to be looking at other things. And Steve from Microsoft this morning, really coming at it from a similar way to myself. And we've also seen in Paul's last session with us, assessing the cloud landscape. What are you looking to do? Because there are going to be different legal answers depending on which flavor of cloud you go with, and there are going to be different risks. What it makes it more risky is what you should be saying. Steve said that the first thing this morning, what makes it more risky? If I identify those risks, how can I manage those risks? In the same way, when I'm a lawyer looking at a contract, looking at a scenario, we've got to assess the landscape. What is it out there that we need to consider? And then perhaps need to protect against in the contract. The contract's a really good tool because it lets you take a standard risk or give some kind of comfort. You can get a commitment, you can get an obligation to maintain, or you can have a right to check, to audit. But they're all things that unless you think of and identify them, you're not going to protect yourselves. So just going through the list of the things that we need to have a look at. We've heard already, particularly from Paul, location of service and data. That starts to have an impact. Who's responsible, who is involved, and therefore who's potentially accountable. We need to be thinking about that. Importantly, talking about the stack, who and what is involved in service provision. You may have a contract. It might be something which starts to protect you, but does that contract protect against subcontractors, against others who are involved in that service chain? And if not, what can you do about that? So that's something we need to have a look at. There are also contractual differences. The methods and style of contracting in cloud are changing. A lot of cloud and a lot of cloud vendors have come from the B2C space. They're used to doing simple contracts, click wrap online, bring them through, onboard a customer, off we go to the next one. That same process is being applied to cloud. And a lot of the protections that you would want or a lot of the protections you would like to seek just simply aren't in cloud contracts. So you've got to start making an assessment of what protection would I need in the contract. But then, more particularly, if you're only paying £1,000 for the service, are you actually going to be able to get those contractual protections? Or is it simply something which becomes risk analysis? And you've really got to identify what rights and what changes you can put into a contract. Because typically, when faced with a standard contract from a cloud supplier, they're going to be rich in supplier rights and rich in customer obligations. The complete opposite of what you were looking to do to protect yourselves as a business. And then finally, we've got regulatory concerns, some other hiccups which come along the way. I'm going to talk about data protection and privacy because I think that's important. That's one of the top hurdles to overcome. But also, if you're in certain regulated markets, there are other issues which you might have to overcome. If you're in financial services, you might have the CISC rules which apply to an outsourcing of a service. We've seen from Paul, this is another type of outsourcing. You may have to comply with FSA codes or other types of best practice. So depending on which segment of the market you sit in, there may be other things which stand between you and a successful adoption of cloud. So almost every presentation you see has got some form of a cloud services model, the sort of stock of multiple options, the different types of SaaS, PaaS, IaaS. We've seen it today. Then there are the other flavors of private cloud, public cloud, community cloud, hybrid cloud. Basically, from a lawyer perspective and to doing your legal analysis, it's important to look at that landscape to really work out what you're going to do and what's involved with the solution. There are inherent risks with certain models. We've seen from Paul there are inherent risks on a security standpoint and different types of exposure depending on who you're dealing with and what kind of service and what kind of solution you're adopting. In the same way, different models will pose different legal risks which you also need to overcome. The compliance requirements, contractual requirements might vary, but the intended solution needs to be understood or explained to you if you don't understand it before you can make that analysis and start to jump through some of these hoops and perhaps start to assemble a contract which is going to protect you. We're talking about a fundamental shift in the way we consume technology, and also a shift in accountability and a shift in responsibility. It is another type of outsourcing. I'm glad to sort of hear that coming through. But in outsourcing, you can't outsource all responsibility. So it's something that's going to remain with you as a business, and something that you need to have considered at least before you sign on the dotted line or kick the services off live. So why does the solution design matter to me as a lawyer? I'm not a technologist. Why are people coming? Why am I asking questions about solution design? Why am I starting to look under the hood of what these cloud services are? Effectively, solution design does matter, partly because you could influence the solution design to enhance legal compliance in the same way you could influence the solution design to enhance your security protection, enhance other kind of protections that you've got. And in a few instances, if you can't change or influence that solution design, you may actually need a different solution. And that's something we've seen. Steve from Microsoft this morning said, if you're that worried about your data in the cloud, perhaps it shouldn't be going in. And that's the kind of thing you need to be thinking about. I think one of the problems as a lawyer, and yes, lawyers always say this, come and see us early, talk about the solution, is if a cloud contract drops on my desk tomorrow and say we're going live Monday, we're going live Tuesday, it's probably too late to perform that legal analysis. So it's effectively you're going in with your eyes open, but there's nothing we can do about it. If at the point of supplier selection, you're starting to ask a few questions about, where's the data going? What's the difference if I go with this vendor in the US versus this vendor in Europe? That's the kind of time that you can use some of this legal analysis to effectively protect yourselves, or effectively choose a solution which is going to work legally. As we've seen, there are solutions out there which may not protect you legally, although they're being sold to many. Just because somebody else is doing it doesn't necessarily mean that it's a legitimate legal solution, as we've seen with an example of CRM from Paul's talk a little earlier on. The good thing is vendors are getting a lot better at understanding a lot of this. They are beginning to look at solution design from a legal perspective and starting to do some redesign. And actually, I'm working with a couple of cloud vendors at the moment really to sort of reconfigure some of their services, or at least assess the services they're building. So when they're built with some of the legal issues in mind. And I think this is one of the things that we've seen in the early days of cloud adoption, is a lot of the services are emanating from the States. They're essentially services which have been designed with the US in mind, with the US customers in mind. They then realize there's a world global potential, rolled out the same service, and not really been aware of some of the problems that could be encountered when you come across different types of regulation and different types of law. So, as I mentioned, you need to sort of define and understand sort of what assets you want to migrate into the cloud and why. And this is going to be influenced by the design of the solution. If you had a design here, cloud with restricted geography, we're only having a data center just outside London, nobody else can touch upon it. From a legal perspective, it's simpler. There are no different locations to consider, and there are no different countries or different laws involved. It's something which, of course, will still have some contractual and perhaps some compliance issues, but it's simple. There are no cross-border flows of data and few touch points upon that data. But that may remove some of the benefits of cloud, or that may actually remove some of the cloud options that are available to you, because in reality, things are often quite different. We've seen you could have CRM from Salesforce based out in the States. You might have a development platform in South America through a PaaS solution. There might be something out in India with IaaS data storage or replication of data. Every time you move to a different location, the applicable laws might be changing. Different laws may conflict, as we've seen a little bit earlier, and I'll talk about a bit later on. And also, your data is suddenly exposed to different jurisdictions, or your local jurisdiction may be saying things in respect of how you handle and what you do in relation to that data. So we need to delve deeper in terms of location. But equally, we also, as I mentioned, need to sort of delve deeper in terms of the complexity of the grid and access issues. And partly this is the sort of thing that's going to come up in security terms, but in the same way, that stack is going to matter in legal terms as well, because essentially with contract and legal protection, we're looking to accountability, and who can we bring accountable should there be ultimately some kind of failure in service or some kind of contractual breach. Just take an example of, IaaS data hosting out somewhere in Asia. You could have automatic geo-replication of that data backing up to a data center elsewhere, perhaps on another location. And then there could be offshore support, little database administrators reaching in to the data center to tweak or to access. They could be based in Sao Paulo, anywhere else. At this point, whilst you're sat there in Europe or the UK with your data center, you've got data moving out to an IS host, it's replicated in another country, and other countries have people and personnel who can access that data. Every time we get a different touch point, there's a service implication, there's exposure to multiple parties, and there are potentially legal challenges from some of the things which I'll sort of highlight in the next slides. You've really got to think about who's accountable. You probably only have a contract in this scenario with this primary IS data hosting partner. There's your contractual protection. If they fail here, fine. What happens if this data center fails? That's a contract presumably between your provider and their subcontractor, and that may be another relationship again. You've really got to think about flowing down some of your obligations or where you're exposed, or ultimately, if it's absolutely significant, whether you can get contractual rights or other remedies against other partners, or whether you want to go with that solution at all. So they're the sort of questions that we need to be asking about. And to talk about the don't fly blind, you've really then got to think about, well, who is responsible for everything? And the first question that we turn to really is the biggest hurdle, and that's one of data. We heard a couple of people this morning talk about the Data Protection Directive and the implications of that. Now, where the most complexity lies is if the data you're using has personal data. So that is data which identifies a living individual. More so because the European Data Protection Directive says if you, as a data controller, i.e. somebody who controls that data and have collected it off an individual, if you control that data, you have a responsibility whenever you give that data to what the EU directive calls a data processor. It places a number of significant obligations on you. Firstly, in relation to being fair to the data subject in the first place. So you actually have to go back and tell the data subject what you're doing with their data. If you're transferring it overseas, you've probably got an obligation to tell the data subject that you are transferring it overseas. So that's one sort of backward-looking step you might need to take. Also, the Data Protection Directive talks about maintaining security, and that includes having a written contract with the processor of your data. And it also talks about not transferring that data outside of the European Economic Area unless you put other protections in place. So straight away, if you're dealing with personal data, you've got a couple of legal hurdles to come across and to get over. So that's something which is really quite fundamental. All the better if you can anonymize the data, and we saw that from Paul a little bit earlier on. I've just been working on a contract where hosting is taking place on a cloud service in the States. It's insurance rating processing, so effectively comparing different insurance policies with each other and looking at the kind of results and pricing which is being charged to ultimate customers. What we did by looking through and assessing the service is they realized the provider didn't need any personal data in order to compare those policies and compare the charges and to rate the policies in question. So anonymize the data, send it off, no problem with the Data Protection Act, tick that box, move on to other issues. So you can really sit down and assess what is taking place. Now, under the Data Protection Directive, if you are dealing with personal data, vendors and other third parties that access customer personal data must do so under written data processing terms. So they're really twofold. That's a requirement of the DPA that there needs to be a written contract. These terms require the supplier only to process personal data on the customer's instructions and to maintain appropriate technical and organizational security in respect to that data. It says very little in data security terms, but it is an obligation. At its very, very simplest form, that means you need a written contract with your cloud provider. I can pretty much guarantee 90% of the time, if it's a US cloud provider, they won't have anticipated that you need that clause within their standard contract. So if you're just signing up to standard terms, you're probably instantly in breach of your obligations in that respect anyway. In fact, what you need to be doing is making an assessment about the type of data and the kind of risk which is that data is exposed to. And there is a number of guidance documents out there around what amounts to adequate and appropriate technological protection and security. But effectively, if you want to oblige your vendor to maintain that security, it's something you need to be putting in the contract, and you need to be prescriptive about the type of security measures that they will employ. Potentially, when you've done your due diligence of that vendor at the point of vendor selection, you've been told about which standards it adhered to, you've been told about which protections are in place. Now, if they adhere to you and they were important to you as part of your supplier selection, perhaps you should be writing those down in the contract to, one, make sure that they're adhered to throughout the duration of the contract, but also that they'll maintain those security standards or those audits or procedures. Because there's one thing having it on day one, but on day two or year two, is that something which they've moved away from? Is it something that they no longer follow? If you don't have the contractual protection in place, you don't have the assurance that the security provisions will be complied with. Often here, we've got a basic non-disclosure agreement in place, so we're okay, aren't we? No, most of the time you're not. Unless it's a fairly complicated NDA or confidentiality agreement, it's not going to be sufficient. Confidentiality is something which is an important part of that protection, but the data protection regulation is something which goes a bit further. So that's one requirement of the cloud vendor. Also talking about data security, it's a serious issue, as we've seen, and you need to retain control. As I've said, there's a technical implementation to what is being implemented, but also this legal and contractual assurance, which I've been talking about. And once that's been established, as I've said, you need to maintain, but also you need to verify and you need to audit. And that becomes particularly complicated if you're in a multi-tenanted environment or in an environment where you can't get in to see that protection. So you may be needing to fall back on other kind of contractual protections, like having the vendor certify to you that they're maintaining certain securities, producing something like a SAS 70 or the new types of audit report which are coming through. But contractually, do you have a right to see that report? Do you have a right to make a change? And if they're not abiding by those rules, what are your options? Effectively, you need to think about termination. Do you need to think about change? Or do you need to think about forcing that obligation on a party? Basically, as a lawyer and as somebody thinking about the contract, you always need to be thinking about the consequence of failure. It's one thing being told, yes, we do that. Quite another thing to see whether they're actually bound to do that and to keep the security or keep the protections in place. So then, let's have a quick look. So then we start thinking about solution design. We're talking about the stack. Effectively, who's involved in processing the services, as I've said, and from where are those services provided? As I've mentioned, frequently you have a single contract with a single entity, but are they contractually responsible if the others fail? Just by way of example, will they require actions of others in the stack to enable your compliance? So if your security view and compliance with security says, I must comply with ISO 27001, if your original contract with your IaaS provider says you will comply with ISO 20001, you probably also need to have a provision saying, and you will ensure that any subcontractor or third party involved in provision of the services will also comply with those standards, because otherwise there's a leak or a breach further down the line. So you need to be thinking about all of those involved within the solution design and within the stack of services to see who is involved and what they're committing to do. Because if you don't have a contract with other people further down the chain, and let's face it, most of the time you're unlikely to, you're reliant on your vendor to ensure those kind of provisions are in place. In the same way, there may also be other rights or IPR or confidentiality issues which give you issues around the solution or solution design. It may be that you owe rights to others which use of the cloud may breach or compromise. And just to give a couple of examples that we've seen recently, a good example is a platform as a service solution based out in the US. People designing their own application on that platform, but when we looked into it, they only had a license to use some of the software that they were building on that application on a UK basis. So it's a typical territorial license. You're licensed to use this software in the UK. Well, of course, popping it into the cloud, moving it out to the States, technically, building something on a different, that use of that software on the PaaS platform was taking place outside of the territory and therefore a breach of the original license. So it's the sort of thing you think, what am I building? What rights do I have? It's very typical for software vendors and others with rights to restrict those rights territorially because that gives them a form of protection or it gives them another mechanism to extract revenue from you. So thinking about those kind of things, what am I putting into the cloud as well as data? Equally, confidentiality. It could be quite typical in an NDA or a confidentiality agreement to say, and you will not share this data with a third party. Well, if you're putting it out into the cloud, is that sharing? Can they see the data? Are they crunching the data? Is that sharing with a third party? Are you compromising other security obligations that you've given to others? So that's the sort of thing you've also got to think about. If you don't understand the solution design and you don't understand the touch points, you can't start making some of those types of analysis, and it can be quite fundamental. More importantly, if you don't understand the solution design, you can't think about geography and that other twist under the Data Protection Directive, which effectively says that you cannot transfer personal data outside of the EEA without ensuring adequate protection. So let's be clear, you can transfer data outside of the EEA if you've put in place adequate protection. So that's one of the common questions that come up. Oh, we can't use the cloud because we're not allowed to transfer data. Well, you are, but only to jurisdictions which the EU determines to have adequate protection. So if it's going to Canada, the EU quite like Canada's rules, and they've said, well, Canada's fine because they have adequate protection in place in respect of personal data. If it's going to the States, the EU's less keen on the US, and you can't automatically transfer data there. You could sign a model contract clause and send the data like that. You could look to see if your provider has EU safe harbor registration and rely on that, but that's only a solution for the US. You see a lot of cloud providers saying, oh, it's okay, you transfer data to us, we're safe harbor registered. Well, safe harbor registration is only as good as for as long as they are safe harbor registered and only good for the US. If you look at a lot of the small print in some of these standard terms from the really big vendors, they talk about safe harbor registration, but in the next paragraph talking about we may federate or use data or data centers around the world from ourselves or with our partners. Well, of course, safe harbor is going to help you for the US, but if that federated data center is in Sao Paulo or elsewhere, there may be another solution. So there's quite a lot of hiding behind data and behind these rules. How am I doing, Emma? 1 minute, 2 minutes, fine. So equally with the US, I'll skip on that one and think about some of the other global implications, because we've talked about the Patriot Act earlier, a lot of noise about the Patriot Act, a lot of noise this week about the Patriot Act, because the Dutch government have started to say, oh, well, we don't like public cloud for our Dutch public services because data might be accessed under the Patriot Act. Now, in my view, a lot of this is protectionism talk and misinformation. The Patriot Act may conflict with some of the data protection laws, but there are adequate procedures within most data protection law which let you release information to other governments in certain circumstances. You've just got to make sure you've got a way of jumping through those hoops. As we've heard from Microsoft earlier, there's no particular test in respect of that kind of situation. But if people are seriously concerned about the Patriot Act, I don't think it is the biggest issue that's on your plates. And in the same way as Microsoft this morning, I think if you're that concerned, it's perhaps something that you shouldn't be popping out into the cloud. And then you've got some of the contractual and commercial realities to think about. This afternoon, I think we're going to have an SLA session, and for some of you in a breakout group, where we'll talk about some of the other kind of protections you might want to put into the contract. But if I could just pop along to some of this dose of reality, there are a lot of things that you could put into a contract. The law is going to say certain things that you have to put in. So there are 1 or 2 clauses around data protection, security, confidentiality, which you're going to have in there. There are a lot of other clauses which are prudent to have. The problem with cloud computing is it comes cheap. And because it comes cheap, vendors aren't particularly keen to negotiate. Also, if it's a service of one to very many, multi-tenanted, it's not possible, or it's not in their interests, to change the service or change the way they behave in respect of different vendors. So effectively, the service is take it or leave it. If it is take it or leave it, effectively that's a risk assessment you're going to make. But more often than not, if you've not made that risk assessment, you don't know where you're exposed. If you do make that risk assessment, you might actually determine, I'll go with a different vendor or I'll go with a different solution. Many of the terms of service are very vanilla, take it or leave it, as I've said, and give a number of problems. So you can spend a lot of a time just getting a contract up to the very minimum threshold without actually then getting appropriate terms or protections in. So if you are in the circumstance of negotiating with a very standard contract, it's probably best to come up with your first 5, 10 things that you really want to change and work on them first before you start inserting the odd reasonable and thinking about the things that are way off down there. In the same way, we don't have a lot of good law which is helping us around cloud. The EU is in the process of a consultation around cloud computing and changing laws. It's a long way off, don't expect anything. In the same way, the Data Protection Directive is under review, and later on this year we'll be seeing some of the changes. We are hearing noises out of Brussels that there are going to be changes which will hopefully help with some of the international transfer issues. But in real terms, there's still a lot of hurdles to overcome contractually and legally, but the biggest problem with a lot of cloud computing is even if you've determined what those rules are and what those problems are, you may not be able to get the change in the contract if you're only paying £1,000 a month. So that's something to really think about and really bear in mind. I know we're pushing on time, so I think that's the end of me. I think the only thing I want to say at the end is there are good cloud vendors and there are bad cloud vendors in legal terms. And the good ones are working and being transparent, they have the right clauses, and they have the solutions design, the capability and the accountability, and they're beginning to come forward with that. Cloud Industry Forum have got a paper out there around good code of practice for providers in the UK. People are beginning to sign up to that and to develop their services, and that's the kind of thing which is good for the industry. And I think the more cloud vendors who really realise some of the questions that you face as customers. There's a lot of other issues to think about in cloud, as you've seen for the rest of today. But don't forget the legal, and don't leave it till the very, very end. And I guess make use of what you can and make use of the advice. And if anyone's got any questions or comments, I'm quite happy to speak a little bit later. So thank you very much.